Good afternoon. My name is Kellie Joyce. I am a partner at the Secrest Wardle Troy office. Today I will be presenting a webinar on the use of statutory immunity in defending ski area claims. This webinar will discuss more in a lot of detail the Ski Area Safety Act, which you will hear me call the SASA, S-A-S-A, which is an acronym for the Ski Area Safety Act. Now, this presentation will address several different portions of the Ski Area Safety Act. First, I will go over the definitions and scope of the Act. I will then discuss the immunity provision in the Act and the use of the immunity provision in the Act. I will talk about the applicability of immunity to hazards not identified in the statute. We'll talk about the application of immunity to chairlift injuries, the failure of the SASA to address tubing, and the use of waivers. First, in the definitions and scope of the Act, there are several key definitions that we will be using throughout our analysis of the Ski Area Safety Act. The first is operator. An operator is a person who owns or controls a ski area or a lift. The next definition is a ski area. Ski area means an area that is used for skiing and served by one or more ski lifts. Ski area also includes those areas that are used for snowboarding, although it's not specifically mentioned in the Act. Snowboarding is considered skiing, so that is included as well in that definition. The next definition is skier. A skier is a person wearing skis or utilizing a device that attaches to a person's foot for the purposes of sliding down a slope. This would include skis, this includes snowboards, this includes anything that straps onto your feet so that someone can slide down a slope. A skier would not include anyone who is not using something strapped to their feet, unless they are a person not wearing skis or a skiing device while in a ski area for the purpose of skiing. So if a person is there for the purpose of skiing, even if they're not wearing skis or a snowboard, for instance, then they would also be considered a skier under the Act. So as you can see, the definitions section is interpreted broadly and includes a number of different definitions. I'd like to go over a few important notes from the definitions section in the SASA. The ski area must contain a ski lift in order to qualify as a ski area under the Act. The definition of a ski area, as I mentioned in the previous slide, does include snowboarders. Even though snowboarding is not specifically enumerated in the Act, it is included in the definition of a skier. Anyone riding on a lift or a tow rope would be considered a participant under the Act. So that means anyone getting on a tow rope or a ski lift, getting off of a tow rope or a ski lift, or riding on a tow rope or a ski lift would be considered a participant under the Act, and they would be subject to the immunity provision of the SASA. Next, ski areas must comply with minimum safety requirements to earn the protection of the Act. These are generally signage and licensure requirements that would be required in order to earn immunity. So we're going to go through later on in the presentation, we'll go through specific checklist that a ski area must follow in order to be protected under the immunity provision of the SASA. Now there are some skiers' responsibilities that are enumerated in the Act. I'd like to go over some of those with you. Specifically, these are set out in MCL 408.342, Section 1. And the skier's responsibilities enumerated under the Act include maintaining reasonable control of his or her speed and course at all times, staying clear of snow grooming vehicles and equipment in the ski area, heed all posted signs and warnings, and last, they can only ski in ski areas which are marked as open for skiing on the trail sign described in Section 6AE. So if the skier fails to follow their responsibilities, then they would be subject to immunity for being in violation of the SASA. The violation of the Act can really hurt their claim, and also from a defense point of view, an argument that the skier was comparatively negligent can also be made, that the skier or the plaintiff did not follow the responsibilities as enumerated under the Act, and therefore they are comparatively negligent. Under SASA, the immunity provision specifically sets forth hazards that are identified. And under SASA, a person who participates in the sport of skiing accepts the dangers of that sport as they are inherent in skiing. And so the SASA sets forth those dangers, which would include injuries that could result from variations in terrain, surface or subsurface snow or ice conditions, bare spots, rocks, trees, other forms of natural growth or debris, collisions with ski lifts, other skiers, tow ropes, etc. The main focus that I want to get across, though, is that the SASA immunity provision is interpreted broadly. Now, in writing the statute, the legislature obviously could not think of every single situation that might arise. So situations arise where there is something that is not specifically identified in the SASA that may cause injury, or something is specifically identified in the statute but it was not used for the purpose it was intended and it causes injury. So in those kinds of situations, the court has to get involved, and that's how we get case law. And there is a situation here where the case of McGoldrick versus Holiday Amusements, Inc., it is a 2000 case. In that case, the court stated that generally a skier or snowboarder who hurts himself in a ski area while skiing or snowboarding cannot hold the ski area liable for any hazard identified in the Act or similar act. Now in McGoldrick, however, there was a hazard that was specifically identified in the Act, but it was not used for the purpose that it was intended, and it still caused injury. So in that case, the plaintiff was injured when he struck a pole that was used for a chairlift, and even though the pole was not, it was identified in the statute, but it was not being used for the purpose it was intended, and it still caused injury to the plaintiff. And the court interpreted the Act and said that the hazard was specifically identified in the Act, and even though it was not being used for a ski lift, since it was identified in the Act, then immunity was proper. The defendant was granted a motion for summary disposition, and in that case, the plaintiff recovered no money. So what we learned from McGoldrick is that anything that is specifically identified in the Act would generally be interpreted broadly, and it would give rise to immunity. So we just talked about a situation where there was a hazard that was specifically identified in the statute. Now, I want to talk a little bit about what happens when there is a hazard that is not identified in the statute, and that's when we get the Anderson test. The Anderson test comes from a case called Anderson versus Pine Knob Ski Resort, Inc. It is a 2003 case, and in that case, the court held that a hazard that is not identified in SASA can give rise to statutory immunity if it meets certain tests that is found. And the court created two elements in the Anderson case, and these two elements must be met in order to provide for immunity. The first is a question whether the hazard was inherent in the sport of skiing, and the second is whether the hazard was obvious and necessary to the sport. So if both of those questions are answered yes, Then the Ski Area Safety Act entitles immunity. The immunity provision will apply. Therefore, even if there is a hazard that is not specifically enumerated in the Act, the courts have interpreted the Act broadly, and if those two elements are met, and the answer is yes, then immunity will apply. Now, there also has been a application of immunity to chairlift injuries. And the reason I wanted to talk about chairlift injuries is because a lot of injuries that we see when they come out of a ski area arise from a person getting on a chairlift, getting off of a chairlift, not being able to use the chairlift properly because someone in front of them backs up, they trip over their skis, something happens, and injuries arise. The SASA has granted broad immunity to ski area injuries that involve chairlifts, and remember, chairlifts also include tow ropes. And I want to point out that the immunity provision has been applied and interpreted broadly, even in claims of negligence against the part of the chairlift operator. And the case on point there is Kent versus Alpine Valley Ski Area. It is a 2000 case, and in that case the court held that a stop button should be utilized whenever there are children involved, and that any lift carrying children should be equipped with a slow button as well as a stop button. In that case, plaintiff's expert conceded that the lack of a slow button did not violate B77, and the plaintiff's experts pointed to no factual evidence to establish statutory violation by defendants that could affect otherwise unrestricted immunity for operators when a skier collides with the chairlift. So the plaintiff in that case tried to get around SASA with a claim of active negligence. The court said, nope, you cannot just try to get around SASA. SASA is interpreted broadly, and a claim of active negligence does not get rid of the grant of immunity to a ski area. So I'm not sure how many of you are familiar with general premises liability cases, but in a premises liability case, often the plaintiff will argue that the premises owner was negligent in order to get around an open and obvious defense. And an open and obvious defense essentially means that if a hazard is readily observable to a user of average intelligence upon casual inspection, then the owner of the property has no duty because the hazard is open and obvious. And usually a premises owner can get out on open and obvious. And to get around that, usually a plaintiff attorney or a plaintiff would plead a claim of active negligence because open and obvious is not a defense to a claim of active negligence. And in this situation in Kent versus Alpine Valley Ski Area, the plaintiff tried to do that same argument. They tried to plead around the statutory immunity of SASA by arguing active negligence, and the court said, nope, the SASA still applies. Now, part of the SASA, although it grants broad immunity to ski area injuries involving chairlifts, tow ropes, snowboarding, there's one area that is not covered by SASA, and that is tubing. Snow tubing, unfortunately, the courts have not concluded that tubing is covered under SASA. And, snow tubing is where someone would take a tow rope up with a tube, they'd go slide down on the tube, and although it looks and smells like a skier in a ski area, courts have not interpreted tubing to be covered by the Ski Area Safety Act. So what does the ski area industry do in order to protect itself against claims by tubers? There's a few things. There's some safety devices and industry standards that are happening that I'm seeing. The industry is creating tubing lanes where there's a specific area that is specifically groomed for tubers, maybe specific roped off area, signs. A lot of the tubing injuries have been happening where at the end of the run where a tuber is unable to stop, so they'll run into something. So I've seen ski areas put up huge stop signs. They've put up, slow down at the end. Some of them have even put like a mat or some hay down at the end, or inflatable barriers in order to help some of the tubers slow down at the end. Your best option, though, in trying to protect yourself and to make sure that you are set up to defend against any claims from tubers would be signage and waivers. Those are my recommendation in terms of the best way to protect a ski area from tubing injuries. You always can do those safety inflatable areas, the mat, the plastic, the hay, the signs. I mean, right now those are becoming the industry standard in terms of protecting from claims against, claims filed by tubers. Those are becoming the industry standard, but they are not the industry standard. But the more we do that kind of stuff, the more, we can say in front of a jury in court that, hey, we have all these safety measures set up. We're not liable for these kinds of injuries. And you can get an expert who can say, yes, this is what the industry is moving towards. But we're not quite there yet. So in the meantime, the best way to protect yourself from a claim by an injured tuber would be signage and waivers. A lot of places are putting on the back of the lift ticket, people are putting waivers on the back of the lift ticket. Make sure that language on the back of the lift ticket specifically includes tubing. Lift tickets with waivers on the back have been upheld by courts as to adults, but not children, and we'll get into that a little bit later in this presentation. They have been upheld as to adults. So make sure you specifically put in there that tubing is part of the waiver on the back of the ticket. You can also put signage at the front and at the front end of the run and at the end of the run. Some examples would be, do not tube faster than you are able to control. Do not touch other tubes. Do not collide with other tubers. Please come to a complete stop at the end of the run. Things like that. So when we're presenting the case in front of a jury is going to see that, we were reasonable. We had signs. We had warnings. We had a waiver on the back of a ticket. We did all of these things to set up safety protocol, and this tuber didn't follow it. And in front of a jury, it makes you look reasonable, so a jury sees that you did all these steps. You did everything to protect the tuber, so a jury will kind of be on your side and hopefully give you a verdict in your favor. Now, speaking of waivers, I'd like to talk a little bit further about waivers in order to address liability. I put a case, Paterick versus 6600 Limited. It's a kind of an older case, 1990. That case basically says that waivers are valid, they are legit, they are upheld in court. They will be upheld as to an adult. If there is a waiver that an adult signed, they will be upheld. In the Paterick case, essentially, there was a man playing softball. He signed a waiver, and then he played softball, and he was injured. The court upheld the waiver that he signed, and his case was dismissed. So again, in a defense to a tubing case, if you can show that the injured tuber signed a waiver or consented to a waiver before going up on the lift or going up on the tow rope, then you should be in good shape. Now, like I said earlier, waivers do not apply when are not upheld when they are signed by parents as to injuries sustained by minors. The case that has come down on that is Woodman versus Kara. It's a 2008 case. Prior to Woodman, waivers signed by parents were upheld. Woodman came down and basically said, no, we are not going to allow parents to sign away the rights of their child. So waivers as to children are no longer upheld in court. In the Woodman case, there was a bouncy house, kind of inflatable bouncy, those big bouncy inflatable parties. a parent needed to sign a waiver for the kid to bounce on the bouncy inflatable things, and the parent did sign the waiver. The kid ended up getting hurt, and the court essentially said that the parent was not able to waive the rights of its minor child, and therefore waivers signed by parents for their minor child will not be upheld in Michigan. Now, there have been some statutory interpretation and exceptions to this general rule, but generally waivers for children are not upheld. So there is a problem when it comes to waivers for children. Now, the Ski Area Safety Act is alive and well. It was created sometime in the 1960s, and there have not been a whole lot of cases recently on the SASA, but there is a recent unpublished case called Marshall versus Boing. That case involved a snowboarder in a terrain park. In that case, there were a variety of places for a snowboarder to do his tricks. And in that particular case, the snowboarder went in the terrain park, was snowboarding, doing snowboarding tricks, and later on that day came back to the same area and was snowboarding again. And in that case, I think it was a half pipe that the snowboarder was injured on while he was going down the second time. And he made a claim that the half pipe was not visible, and that's why the SASA should not apply. And in the case of Marshall versus Boing, the court said no, SASA was upheld. There's no liability. The snowboarder should have seen the half pipe area where he was injured when he went down the half pipe earlier in the day, and SASA was upheld. Now, the reason SASA was upheld is kind of enumerated on this next slide here. The court found that by choosing to ski or snowboard in the terrain park where the snowboarder chose, it was clearly marked with signage, which we talked about earlier. Signage is key, as required by SASA, and which contained the half pipe that the plaintiff saw earlier in the day. The plaintiff was held to have accepted the danger as a matter of law. Now, the plaintiff bar on these claims is trying to rebut a lot of the testimony, a lot of the court's cases and the statutory immunity, and I've seen one plaintiff expert that has been trying to get around the statutory immunity provision, and in order to get rid of this expert testimony, what we've been doing is we've been sending directed discovery, filing motions for summary, and we've seen that the court has upheld the SASA. It is alive and well. It is interpreted broadly, and it does not seem that the courts are going to be getting rid of the statutory immunity provision anytime soon, especially given the Anderson test. The courts have really found that when those two elements are met, even if it's not specifically enumerated, that the SASA will apply and the statutory immunity provision will be upheld. So as a takeaway of today, Ski Area Safety Act really is a great way to defend a claim. As long as you have the signage, and as long as even if there is a hazard that is not interpreted, that is not specifically enumerated in the act, make sure you follow those Anderson tests, whether the hazard is inherent in the sport of skiing and whether the hazard is obvious and necessary to the sport, and generally the Ski Area Safety Act immunity provision has been broadly interpreted, and with terms of chairlift injuries, statutory immunity has been applied. The only area where I have not seen statutory immunity apply, again, is with tubing injuries, and to protect yourself from a tubing claim. Again, signs, try to put signs at the beginning of the run, at the end of the run, and waivers. Waivers are your best friend here, especially with adults. With children, I think the biggest thing you can do is the signs, and generally you'll find that the courts will interpret the act broadly. That is pretty much it for the webinar today. I thank you very much for attending, and if you have any questions about what I've gone over, please feel free to contact me. I encourage you to contact me early if you see something. Give me a call, send me an email. I do a lot of work in premises liability, but I also can be available to assist in any claims or any situation involving automobile, first party, third party, trucking incidences, any construction claims as well. So thank you for listening, and I appreciate your time. That is the end of the webinar.